Hello, and welcome to California Gun Law. I'm your host, Don Hammond. In this episode, I'm going to talk about carrying a gun with a valid California CCW license and issues surrounding alcohol. Carrying in places that serve alcohol is prohibited. Drinking while carrying is prohibited, but let's dive into these laws to see what they really mean. I'm a licensed California attorney and a shooting instructor. I regularly help teach the 16-hour class that's required to get a concealed carry license in California. And on this program, we provide education on California's complicated web of gun laws so that responsible gun owners like you can better understand how to lawfully exercise their rights. California has a complicated web of firearms laws and regulations, and there are lots of traps for the unwary. We want to help you do it right so you won't need our criminal defense legal services. Today, I'll discuss carrying a gun in California with a valid California CCW license and what that means for going into places that serve alcohol, drinking, being under the influence, etc. First of all, I want to say drinking and guns don't mix. I had a friend a long time ago who went out to the desert shooting with friends. The group of friends was also drinking, and my friend ended up with buckshot in his arm from a shotgun, which was still popping to the surface for years. So please don't mix alcohol and guns. Let's take a look at California's laws on this subject. As far as California law for a CCW holder, Penal Code Section 26200A2 prohibits you from being in a place that having the primary purpose of dispensing alcoholic beverages for on-site consumption. So that covers bars primarily, but also wine shops, and other places that have alcoholic beverage as their primary item for sale for on-site consumption. This is sort of the classic law. It's been in effect for a long time. Everybody kind of knows you don't go into bars if you're carrying. Part of Senate Bill 2, which took effect on January 1st, 2024, created a bunch of sensitive places. Now, a lot of these are subject to litigation in a case called May versus Bonta, and there's an injunction from the Ninth Circuit back in September that still has a stay on a lot of these places. But one of the sensitive places, which is currently not a part of the injunction, so it is in effect, is Penal Code Section 26230A9. That prohibits a CCW holder from carrying a gun in any building, real property, and parking area under the control of a vendor or an establishment where intoxicating liquor is sold for consumption on the premises. As a practical matter, this can be a challenge. It applies to any bar, any restaurant, any place that sells alcohol for consumption on the premises. If you decide to go to lunch at a new place and you think they don't serve alcohol, but you walk in and see a beer tap, what do? I think the correct answer legally is you have to go back out to the car and legally store the gun. Of course, as I've pointed out several times in other videos, you can carry in the vicinity of your vehicle, lock the gun in your car safe in the parking lot, pursuant to sections 26230 subdivision C and also 25140. And you can retrieve it after you come out of the restaurant. So that covers places that serve alcohol. Then there's section 26200A3, which prohibits you from carrying a gun while under the influence of any alcoholic beverage, medication, or controlled substance. So putting these three penal code sections together, you can't carry in a place that serves alcohol. And I have previous videos about the penalties of what happens if you do. And you can't carry while you are under the influence. But legally, under the influence means more than just having alcohol in your system. The alcohol must actually be affecting you. I handle a lot of DUI cases, and in that context, under the influence means that one's mental or physical abilities are so impaired that they're no longer able to drive with the caution of a sober person using ordinary care under similar circumstances. That's in the jury instructions. A jury can't legally convict you of driving under the influence just for having a small amount of alcohol in your system if it's not actually affecting you. So if you want to be a test case, there may be legal room for someone who drinks a beer while unarmed and then straps up. As long as you don't rise to the level of being under the influence, you may not be in violation of any of these laws. If you do that and get stopped while walking home, There's even a federal district court case where a motion to suppress evidence was granted after a police officer prolonged a detention to investigate someone solely because they observed signs of intoxication and the defendant was carrying a concealed firearm. The case is United States versus Shepard out of the Eastern District of California, and it was decided on September 6, 2024. That case would be persuasive authority, not binding authority, on a California state judge. And I wouldn't expect a California prosecutor or judge to take very kindly to someone who is carrying a gun after drinking. So I don't recommend it, but there's no legal waiting period. Nothing in the law says you have to wait 4 hours or 8 hours or any amount of time between drinking and carrying a gun, as long as you're not under the influence. So you might set a personal policy. In aviation, we call these personal minimums. So tell us in the comments if you have a personal minimum about how long you would wait after having a beer before you would carry a gun. I'm Don Hammond of California Gun Law. We'll catch you all next time. Stay informed, stay legal, stay safe.